patience. I think at the right time when it comes to immigration. But I think public health is still being assessed. I have clients that have attended interviews, done our course. So here's the thing: petitions are being processed, interviews are being conducted, except that visas are not being issued. Okay, so that is the difference, right? Interviews are being conducted, except that visas are not being issued. So that is what you need to know. If anyone tells you that the pause has been lifted, that is not true. Okay, I believe we are live on Facebook now. A very good evening to you all. I hope you're doing well. Please, when you log on, kindly share so that others would join as well. This is a Q&A session. This is an immigration Q&A session. If you have any immigration questions, please feel free to type it in. I am going to answer as many questions as I possibly can. My name is Akosua Kisi. I am an immigration attorney here in Springfield, Virginia. I'm licensed to practice in all 50 states. And as far as immigration is concerned, we do everything immigration. Okay, employment-based, the EB1, EB2, NIW, naturalization, VAWA petitions, court representation for those who unfortunately are in removal proceedings. We can represent you in all 50 states. And so if you're looking for an attorney to help you in your immigration petitions, please give my office a call. We are located in Springfield, Virginia. But we have systems and structures in place to serve clients across all 50 states and the globe. I have clients abroad. And so our systems are friendly. Recently, a prospective client in a consultation session said that she doesn't know how to use a computer, which I found to be very funny and quite interesting. But then I asked her what phone she uses, and she said she uses an iPhone. And I said, listen, that's all that you need. So no matter where you are, we will be able to represent you. Okay, so feel free to contact us, head to our website. We have reviews there on our website. We have videos of clients, testimonials as well. And so check us out, okay? But if you have any questions, please type it in. I see lots of questions on TikTok already. I'm going to answer them. I don't see any question on Facebook yet, but we will take as many questions as we possibly can. So let us scroll up and then see. Okay, someone says they're joining from Tema. That's great. Thank you for joining. Someone says Accra. Thank you. Okay. All right. So if you get a 10-year green card, but your marriage was under 2 years, I still need to remove conditions? Yes, you have to remove your conditions. You have to remove the conditions that was placed on your green card when you did receive it. You cannot jump from, unless you receive the 10-year green card straight away, you simply cannot jump from 2 years to citizenship, right? So you still have to remove the conditions from your green card. I hope I've answered your questions. Okay, someone says, what evidence do I need for my Form I-130? There are a number of evidence that you need. Lots of evidence that you need to prove that your marriage is bona fide. Number one, you need pictures, right? What I have seen is that people submit selfies. Yes, we take selfies, but you cannot submit only selfies to the USCIS when you are petitioning for a marriage-based green card. You need pictures that shows that you hold yourselves out as a couple in public. So when you go out for your dates, you take pictures. When you go to the grocery store, you take pictures. When you go to church, you take pictures. When you attend your parties, you take pictures. You attend funerals, you take pictures. And day to day, of course, when you're home, sometimes you do take pictures as well. And so your pictures can not only be selfies, you should be able to hold yourselves out as a couple. You also need to establish or prove that you live together, okay? And the evidence that you need to prove that is going to be a joint lease agreement. I understand that sometimes because the immigrant, the foreign spouse, does not have a social security number, sometimes you are unable to put them on your lease because some of the apartments or landlords will require that they see a social security number. I understand that that can happen. Now, if that happens, then what you want to do is to get their names on utility bills, right? On some of the utilities. If the lack of social security number is still a major concern, then you can simply put a notarized statement together. You know, there are so many ways around this. There's so many ways around this. You can put a notarized statement together stating that yes, you live together, but because of the lack of social security number, you're unable to get your spouse, your foreign spouse, on your lease or any of your utilities, and that is that is real, right? That is true because I have clients who are unable to get on there just because they don't have social security numbers. Now, you're better off putting a notarized statement together than lying to the USCIS. I'm going to talk about immigration fraud at some point in this session. And so, yes, you have to prove that you and your spouse cohabit, and that is the evidence that you need. Also, a joint bank account, or a joint bank statement. Okay. Again, there can be the issue of the lack of social security, but I also know that a bank like Capital One does not require social security, at least for the Capital One banks that most of my clients have used. I don't know whether every location is different, but for some of the Capital One banks and in the location, I mean, they simply had to open the account online. They didn't even have to visit the bank physically. It was online. There's PNC. I see that PNC also does that. The challenge I've had clients have is with Chase and then Bank of America, and then also Navy Federal. So some of the banks would not allow you um, open a bank account if your foreign spouse does not have a social security number. And so that is something to look out for as well. But there are so many pieces of evidence that you can submit, okay? And ordinarily, when you're getting married, you have friends and family there, right? So you need witness statements. People should be able to attest to the fact that you're married. And so you need witness statements. You need a joint insurance, at least a life insurance, which also helps. Okay, if you have done some trips together, you can add evidence of that trip that you've done. So you've taken together, you've attended concerts together. These are some of the evidence that you can submit to the USCIS to show that your marriages are real. All right. So for the one that answered that asked that question, I hope I have answered your question. Okay. Okay. A Ghanaian living in America. Okay. Yeah. I think I have to read this question to my head before. Okay. I Baby Ruth, I don't understand your question. So if you're asking your questions, please make sure it is clear enough so that I can understand. Okay. My youngest daughter, age 25, unmarried. Can I petition for her from Ghana to the United States? You can, but it's going to take a very long time. I mean, you can petition for everybody or anybody, so long as they do qualify, but it's going to take a very long time. Okay. So that is that. There isn't more that I can say. I can say to that. It's going to take a very, 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 very long time. Okay. I have a question about my I-130 petition for me by my daughter, and I want to know how long it would take. So your question is, your daughter has filed the I-130 and you don't know how long it's going to take. I also don't know how long it's going to take. When it comes to immigration, I mean, I'll tell you this. I'm seeing I-130, I-485 being processed slightly faster than before. I have seen decisions in as short as 3 months before, right? That is for those that are here in the United States. For those that are abroad, it's taking a very long time. And you know, Ghana is part of the countries that are experiencing the visa pause. And so even if your I-130 is approved and consular processing kicks in and that whole process is done, you may be able to attend your interview. I have clients that are attending interviews, except that visas are not being issued. So it's going to take some time. It's going to take a while. All right. Okay. Someone says, can I file the I-485 together with the I-130? It depends. Okay. That is a concurrent filing. It depends. If your spouse or the principal applicant is a US citizen, then of course you can file the I-130 and the I-485 together. If they are green card holders, you cannot do concurrent filing. You have to wait for your priority date to become current. Okay. It is only at that point that you are able to file an adjustment of status. So it depends. Okay. It depends. The answer is it depends. If your principal applicant is a US citizen, then they can go ahead and do concurrent filing. That is, file the I-130 and then the I-485. If they are green card holders, they can only file the I-130 and then wait for the priority to become current. And then other points, they can adjust their status. You won't be able to file concurrently if the if the principal applicant is a green card holder, unless they are US citizens. Okay. Baby Root says, can we adjust in the US with regards to the ban? So yes, you should be able to, but I think for the past 2, 3 weeks, I've had so many people contact me and say that the USCI says that they cannot adjust their status. So the directive was that the pause was affecting those abroad. It was the issuance of visa for consular processing, at the US embassies abroad. But at least I have about 3 or 4 people that have contacted me that the USCIS, even yesterday, that the USCIS says that they are not processing their petitions simply because they are from one of the countries with the visa pause. I believe that whoever the USCIS officer is, do not know what they're saying really, because based on the directive, they should be able to process the petition. So if you have an attorney, get the attorney to contact the USCIS. They can request to speak with the supervisor and then get clarity. That is my advice to you. If you file the petitions yourself, then please, 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 please make sure that you contact the USCIS yourself. Okay. Okay, so someone says, good evening. How long does it take to request for legal net from the embassy in Ghana, please? It depends. I mean, when it comes to the embassy in Ghana, it depends. It depends on the backlog. That's basically all I can say. But it shouldn't take it should take about a couple of months. It shouldn't take more than 6 months. So Nana Kwabna, if it has taken more than 6 months, then you want to keep knocking at their doors to see what is happening. It shouldn't take that long. All right. Okay. All right. I'll take a few more questions and then I'll give you some updates. All right. Okay. So someone is asking what evidence do I need to file for VAWA? I am the spouse of a US citizen. Okay. All right. So if you are the spouse of a US citizen and you have evidence of abuse, you may be able to apply for VAWA. Now, when it comes to abuse, it doesn't only have to be physical. All right. The abuse doesn't always have to be physical. It can be emotional, it can be psychological. And so if you don't have evidence of physical abuse, it does not mean that you won't qualify for VAWA. Now, I know it becomes a bit difficult when you have to prove that the abuse is psychological. That is where you get your psychological evaluations done, right? It's also very important that you are able to detail an account of everything that has transpired in your marriage, the treatment you have received from your spouse, how they rise to the level of abuse. And then you should have friends and family, the people you confided in when you were going through all that abuse. They should be able to attest to that. So they should be able to put a written statement together, right, and then get it notarized. It's very important that you notarize these statements. It shows that you are not lying. But if you're lying, please don't, because there's a surge in immigration fraud now, and I'm going to touch on that in a few. And so if you know that, most people, we are immigrants, right? I understand. It's not the right thing to do, but I understand. Sometimes you put yourself on the dating market, you get married, and then you believe that, oh, once I'm married to the US citizen, at some point I can just walk out of the marriage and then file for VAWA. It doesn't work that way. You have to prove the abuse, right? You need lots of evidence to prove that. And the truth is, when it comes to VAWA, previously, I mean, even till now, the standard or the bar is quite low. But then now people are being interviewed, applicants are being interviewed. Previously, and this is because there was this case in New York with a Ghanaian attorney that filed, I think his name is Kofi, that filed VAWA for lots of people, and took them lots of money, into like the millions, right? And so now, and most people, I mean, USCIS immigration officers know that most people file for VAWA when they really don't have a VAWA claim. And so it's important that you are able to prove that you have suffered abuse, right? It's not enough to just say that I'm going to get married and then walk out of the marriage. And immigration has changed significantly now. Things that were quite easier to do now, it's not that simple. And there's immigration fraud. There's a surge in immigration fraud. Yesterday, on Wednesday, in our webinar, I spoke to a lady whose story was the exact same case I'm handling with a client now. So she entered the United States with her husband, and then, for some reasons, as soon as they entered the United States, they began to have marital problems, and so they filed for divorce. And both of them put themselves on the dating market with 3 kids. Both of them put themselves on the dating market, get married to US citizens, and then the man decides not to file immediately, but then the lady decides to file immediately. So the lady files and then, comes back to me and say that, oh, I want to switch to VAWA because I can't find my husband. And I have a child with this new husband, but then I decided to name the last child, which is the 4th child. I decided to give my ex-husband's last name to this 4th child. And I remember asking her, let us sit with you for a second. If you have been married to someone for about 15 years, and then out of nowhere, you enter a foreign country and so you divorce, and then you get married to someone, and around the same time, you give birth, and then you say, well, my current husband isn't treating me well, and so I want to name this last child after my husband because I don't want my ex-husband's kids to have different names from this last one. Immigration officers are not silly. They think, right, just like you. And so you cannot throw some of these things at them and not expect them to see through it. And so when you decide to put yourself on the dating market and then you don't ask all the necessary questions that you're supposed to ask, or you don't get in with a certain strategy, and then you think because VAWA worked for someone, you're also going to file for VAWA. It doesn't work that way. You have to prove that you're really eligible for the visa category that you are petitioning for. All right. And so yes, VAWA, you don't necessarily have to prove physical abuse, but there are pieces of evidence that you need to submit, right? Just in case the USCIS comes to investigate. I believe a couple of months ago, someone reached out to me. I had a consultation with a prospective client, and then the client had received a denial notice from the USCIS based on a VAWA petition that she filed. The USCIS had contacted 4 people, so she submitted 6 witness statements. 4 of them were her friends that at the time the USCIS contacted, they were no longer friends. By the time she was filing the petition, they were friends. And apparently she didn't have a VAWA claim, but then they thought they could beat the system. And so the friends decided to come together and then write statements, except that they didn't notarize the statement, right? They write these statements, submitted to the USCIS as part of the VAWA packet. And then by the time USCIS is conducting an investigation, they realized that, I mean, the lady didn't really have a VAWA claim. As I speak to you now, she received a notice to appear in immigration court that has triggered her removal proceedings, right? And so you have to be mindful that a certain pathway worked for someone 5, 6, 7 years ago does not mean that same pathway is going to work for you. Before you decide to file for any immigration pathway, make sure that you speak with an attorney to explore all possible options, all possible pathways, and then get the attorney to advise you on the pathway that best fits your situation. You want to make sure that you're positioning yourself well, because if you don't do that, then that's going to come back to hit you. So for the one that is asking if you are married to a U.S. citizen and the marriage is not working, you can file for VAWA. It's not that your marriage should not be working, it's that you have suffered some form of abuse. And that abuse, again, doesn't have to be physical. It can be mental, it can be financial, right? I found VAWA petition for someone who was able to give me proof that they were being threatened all the time. Their spouses were threatening them, and they had messages to that effect. I remember one particular case. The lady gave me evidence that the husband says that he wanted them to have a threesome, and she doesn't believe in that. And anytime she declined, the husband physically abused her. She couldn't give me proof of that, but she was able to give me messages to show verbal abuse. And she also sent me some recording. You don't have to record your spouses, okay? You need permission to record them. If you record someone in a conversation, you simply cannot present that in court. It's a crime to record someone without their consent. And so those are not pieces of evidence that we could use. But for messages, emails, these are evidence that we can submit to the USCIS. And so this lady, I mean, there were overwhelming evidence where the husband is saying that I want us to have a threesome, messages, emails, and then when the lady says no, I think in one of the messages, the lady had come back from the grocery store and the door was locked. I think the keys had been changed, and so she had to stay out, and then she documented. The first time she reached out to me and said, you know what, document as much as you possibly can. So it was one message after the other, one email after the other, because there was a point where the husband blocked her. And so I said, you know what, send him an email, he's going to reply. And so she sends email, the guy responds, and then these are all pieces of evidence that we got to put together, and she's been good so far. And so yes, you don't necessarily have to be physically abused to qualify for VAWA. All right, so for the one that asked that question, I hope I have answered your question. Okay, so what is happening with the EB2 NIW? I don't understand your question, but there's a lot happening when it comes to the employment based. Okay, we're seeing lots of RFEs, we're seeing lots of NOIDs, that is the notice of intent to deny. Um, Lots of RFEs and denial rates really high. And that is because of what I have studied so far. The trend that I'm seeing now is, are people still getting approvals? Yes, we have clients getting approvals. This past week, we received an approval for a client's R1, which was it was a very difficult case. This case was really difficult because the USCIS issued um, an RFE, and I remember reading the RFE and had to shelve it for some time. I read the RFE, shelved it for 2 days, and then later got back to it, jumped on the phone with a client, and then proposed a strategy to respond to it. Sometimes the USCIS officers, the truth is sometimes they misapply the law, right? Sometimes they misapply the law. So one is important to know the law when you are petitioning for any immigration benefits, especially for the employment based and then the special immigrant visa cases, right? It's important to know the law. When it's misapplied, then of course you can go back to the officer. I recently have filed an appeal for a client. After reading the notice, the client received a denial for his EB2 NIW. After reading the EB2 NIW denial notice, I said to this person that we just have to appeal because clearly the officer misapplied the law. And it's important to know the law. If you don't know the law, that is for those that decide to file these petitions themselves or use preparers, right? If you don't know the law and an officer misapplies the law, you won't know. That's just what it is. You won't know. But when you work with an attorney who hopefully knows exactly what you're doing and your petition is denied, you can appeal, right? You can file a motion to reopen, to reconsider. You can simply appeal the decision, and the USCIS is going to look at it again. So long as you're able to prove to them how they misapply the law, they're going to look at it again, right? And then do the right thing. But if you don't work with an attorney who knows what they're doing and you work with preparers, one, you preparers are not held to any standard, unlike a licensed attorney, right? And so you have to be mindful. So there's a surge in RFEs, lots of denials, but of course, petitions are also being approved. One of the things that I have seen is that the USCIS is focusing heavily on the proposed endeavor. Proposed endeavor is what you want to do, what you intend to do in the United States. Okay. Now, it's important that your proposed endeavor is not broad, it's not vague. It has to make sense. It has to state a problem that you're looking to solve, how you're going to solve that problem, and how that problem is going to benefit the United States as a whole. Right. It has to be very specific and feasible. It also has to show the strategy and the tools and framework that you're going to use in solving the problem. It's not enough to identify a problem in your proposed endeavor, right? It's one thing to identify the problem, it's another thing to prove how you are going to address that problem you have identified. What framework, what strategy, what tools are you going to use to solve that problem? And what is the execution plan? That is what your proposed endeavor is supposed to do. I think beginning of this month, someone retained, two people actually retained us for the EB2 and IW. And I tell them, everyone is very quick to say, how long is it going to take? How soon can we file? It's not about how soon we can file your petition, right? And I have been doing some back and forth with this particular client, and thankfully they understand. And when you explain to clients in consultation the process, I believe it doesn't click until you actually start the process. There are other attorneys that would work with any endeavor you send to them, we take our time to review the endeavor and make sure that it makes sense. It should make sense to my grandmother in Ghana, right? Because the officers that are going to review your endeavor, those officers are not experts in your field. And so your endeavor should not be so technical that they won't understand. If I read your endeavor, your proposed endeavor, and I don't understand your proposed endeavor, there's no way an officer is going to understand it. So your proposed endeavor should identify a problem, number one, how you intend to solve that problem, what tools or framework you're going to use to solve that problem, and what is the execution plan in solving that problem. And lastly, how is it going to benefit the United States? Because USCI, the RFEs that USCIS are issuing to attorneys, preparers, and I've seen so many of them because sometimes people file the petitions on their own, and then once they receive an RFE, they're scrambling around to find attorneys. There are those that work with other attorneys who just put the petition together based on whatever was sent to them. And then once they receive an RFE, then they're looking for someone else to take a look at it. But then based on the number of RFEs I have seen, the attorneys that I have spoken to, USCIS is focusing heavily on your proposed endeavor. So remember, it has to show exactly what you want to do, how you will do it, who is going to benefit the United States on the benefits to the United States. It has to be broad. Okay. So identify your problem, how you're going to solve that problem, what tools you're going to use to solve that problem, and your execution plan. Once you're able to do that, your proposed endeavor should be good enough. So for the one that is asking what is happening with EB2 and IW, that is what is happening. So as of now, the priority date for EB2 and IW is current. And so many people are taking advantage of that. Please take advantage of that. That means that when you file your petitions and you get an approval, you should be able to adjust your status. Take advantage of that if you do qualify. And if you want to know whether you qualify, head to our website, www.ablegalconsults.com/NIW. I'm going to post the link somewhere. If I have any member of my team here, please post it on TikTok for me. I'm going to post it on Facebook as well. If you want to know whether you're eligible, please complete this and then upload your CV, submit it, and please, when you do, give us at least 3 days. Give us at least 3 days to be able to determine your eligibility. Once we make that determination, you are going to receive an email on the next steps. So most of the time, we recommend that you schedule an hour consultation, and this is why. Within that hour, we are going to walk you through the eligibility. We're going to share our screens. My team and I will share our screen. We walk you through the eligibility. We let you know the pieces of evidence that you need for each criteria. And then we'll discuss the process, timeline, fees, and most importantly, answer any questions that you have. When we say clients should schedule 1 hour, it's always a challenge. But here's the thing, when you schedule an hour consultation, the fees you pay for that 1 hour is applied to the attorney fees. So technically you had that consultation for free, right? It's applied to the attorney fee. So you're not losing anything, as it were. If you schedule for 30 minutes, we're going to rush through the consultation because we have to capture everything in 30 minutes. And most of the time, people schedule 30 minutes and we are unable to get through. And once you're rounding up, oh, attorney, I have one more question. How? No, I don't think that is fair to us because we do so much work, right, with the evaluation of your CV or your portfolio. We do so much work with that. And anytime we have shared the screens with prospective clients, they attest to it. And so please, 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 I think the link has been posted on Facebook and on TikTok. Complete it, upload your CV, let us determine. And you don't, so let me say this, you don't have to be physically present in the United States to file for the EB2 NIW. You can be anywhere across the globe. You don't have to be physically present here to file for the EB2 NIW. All right. You don't have to be here. It's one of the questions that I get a lot. And you don't need a PhD. Let's demystify that as well whilst we are here. You don't need a PhD to qualify for the EB2 NIW. You also don't need publications to qualify for the EB2 NIW. If you are a researcher, predominantly what you do is to research and publish. So if you're a researcher and you come to me and you don't have any publications, that is a problem, right? But if you're not a researcher, you don't necessarily, if you have it, that's fine, but you don't necessarily need publications to qualify for the EB2 NIW. For those that also want to, I just saw a message on TikTok. So for the EB1, it's almost the same, right? The EB1 is different from the EB2 NIW. Any member of my team here should please post the link for the EB1 as well. So for the EB1, it's for people that have risen to the very, very top in their field of expertise. You don't have to be working for 15, 20, 25, 30 years to qualify for the EB1. I've applied for EB1 for people that were in their late 30s and they did qualify. They did get an approval. People in their 40s, people that have been working for just 7 years, 6 years, 10 years. I'm yet to apply for anyone that has been working for 2 years. But yeah, you should have risen to the top of your field to be able to qualify for the EB1. So for the EB1, there are 10 criteria you need to meet, at least 3. In the past, I would work with people that meet only 3, but now I would not, because the times have changed. The USCIS is processing this slightly different. Last month, I received a NOID, which is a notice of intent to deny, for 2 EB1s that I filed for clients. And for these 2, I mean, we received the approval, but I want to give you the backstory. For these 2 clients, what happened was we went in with 6 criteria. What we are noticing now is even after you have met, so generally after you have met at least 3 criteria, there's a step 2, which is the final merits determination. So this is where the officer takes a step back after the applicant has met the regular criteria, right? After the applicant has met the regulatory criteria, then the officer takes a step back to see whether, okay, when I put all of this together, the totality of the circumstances, when I put everything together, has the applicant risen to the very top of their field? Should they have sustained national acclaim? That is the step 2, the final merits determination. And that is where the USCIS is exercising their discretion a lot more recently. And so after you have met these criteria, USCIS is just issuing notice of intent to deny, and then they're giving you only about 30 to 33 days to respond. And this is where you need an attorney, right, to make a solid argument for you to be able to get you the approval. Thankfully, we have received approvals for our clients. And so, I mean, I know preparers are cheaper than attorneys, but you also want to work with someone who you can hold to a certain standard. You cannot hold a preparer to any standard, as it were. But if you work with an attorney, you know that if anything goes wrong, at least you can report the attorney to the bar, right? You can. I'm not saying you cannot sue a preparer. You can, but you can't hold a preparer to any standard like you can with an attorney. So that's what is happening with the EB2 NIW and then the EB1 as well. All right. Marriage-based petitions being approved. Yes, marriage-based petitions are being approved. Actually, marriage-based petitions are being approved faster now than before. What I have seen so far, and I can count about 4 clients of mine whose petitions have been pending since maybe beginning of last year, and their stories are the same, very similar. These are people that enter the United States with their spouses, and miraculously, they have issues with their spouses, and so they divorce, they put themselves on the dating market, and then they marry US citizens, and then they file for marriage based petitions. What I'm seeing now is that for those people, the USCIS is conducting investigation a lot more, right? And I'll tell you the number of denial notices I have read from prospective clients, and these denials are based on immigration fraud. The number of notices I have read based on immigration fraud in the last month, I have never seen in the last 1 year. So there's a surge in immigration fraud, right? So immigration fraud is not only about fake marriages. It's not only about lying to the USCIS that I live with, my spouse at this address when I don't. It's the very simple things as omitting that you have a child, misrepresenting yourself, lying in your interview, saying in your DS 160 or stating your DS 160 that you're married to get a visa when you are not married, right? And so you come in. I at least I consulted this year. I've consulted with about 6 people, and this is only April. I've consulted with about 6 people with similar stories, right? Out of desperation, they stated in their DS 160 that they are married. Of course, because you have to establish some ties back home before you enter the United States. And so they stated in there. But the trick is that the consular officer who is interviewing you rarely asks you to show them your marriage certificate. And so sometimes you're able to get away with that lie, right? You're able to get away with that lie. And so these people stated in their DS 160 that they were married. They got the visa, they came to the United States, and because they were actually not married and didn't understand the repercussion of stating that they were married in their DS 160, they put themselves on the dating market here, found US citizens, got married to them. In fact, one person actually got her 2-year green card, her 10-year green card. And then it was when she was filing to become a US citizen that the USCIS officer said, you didn't even qualify for that green card. So I have seen a lot of this year, right? The things that we say or state in our DS 160 when we come in, when we are trying to come into the United States, always come back. So is marriage-based petitions being processed? Absolutely. Like I said, I've seen approvals in 4 months, 3.5 months, 5 months. And for those whose petitions have been pending for over a year, this has been the trend. There's always something. There's always something. Recently, someone reached out to me, and when she got married to the US citizen, she had entered the United States, of course, with her husband from Ghana, and filed a divorce. And well, in her immigration petition, she lives with her US husband, right? Because she's divorced the one she entered the United States with. So she's married, and on paper she lives with this one. But what she had forgotten was she had purchased the property here in the United States, right? She had purchased the property, and she purchased the property with cash in the United States. And so USCIS saw through that. Okay, you enter the United States with a man, you're divorced, that's fine. You marry a US citizen who has a house. You have filed the petition, and it shows that you live with this US citizen in his house. But you've also purchased a property that has your name on it. Bills come to the house with your name on it. The presumption is that you live there. And unfortunately, in the system, There's another man whose name, whose letters also comes the same address. So there's another man in the house who receives letters in the same house. So the presumption then became you live with another man in this new house, but on immigration or in your immigration documents, you live with a U.S. citizen spouse, and that triggered investigation. And then the petition got denied, charged with immigration fraud, and currently in immigration court. And so immigration fraud is not just about the fake marriages. There are things that we state in our forms, there are things that we omit. As men, sometimes when you're entering the United States or when you're filing for your marriage-based petitions, you fail to disclose that you have kids. Sometimes you can get away because the issue then becomes, does your omission rise to the level of material misrepresentation? If you are a man and you file for immigration petition and you don't disclose that you have children, there can be a leeway around it. Let's say you didn't even know the children existed because the woman didn't tell you, and of course you're married to someone else, and so if the woman didn't tell you that you had kids, that's okay. But then the other issue then becomes, how old are these kids? If they are quite older and you have been in Ghana throughout, or you've been abroad with these kids for a while, then there's also the presumption that you knew the existence of these children. But if these kids are really young, then there can be a leeway around it, right? And so be mindful of the things that you say. And then also your social media. You can, your immigration petitions cannot state one thing and then your social media communicates something else, right? So if you are petitioning or requesting for any public assistance, or in your immigration petitions you stated that yes, you're taking some public assistance somewhere, but you're living a big luxurious life on social media, that's a problem. If you are filing for marriage-based petition and on social media you are posting your supposed girlfriend or fiance or your wife or another woman, then of course you're also misrepresenting yourself, right? You are contradicting whatever information you have presented to the USCIS, which is different from what is on social media. And so I have seen these things play out differently from all the denial notices that people have consulted me with, the denial notices that I have. Man, I can write a book on the denial notices I have seen only this year. And the detailed investigations that the USCIS officers are conducting is scary. And so please be mindful when you apply for your immigration benefits, and then you're also putting yourself out there. You have to be mindful. Okay, so what are some of the things to consider before I marry my US citizen spouse? What are some of the things you have to consider if you're getting married to someone? You want to investigate, you want to make sure the person is who you really want. You want to make sure the person file their taxes, at least especially you're going to file for immigration benefits. And you're not entering the marriage for the sole purpose of immigration benefits. Okay. Once you do that, then you're committing immigration fraud. If you don't want to enter into any marriage for immigration benefits, you want to enter into the marriage because you intend to spend life or do life with this person. So you're entering into this marriage on good faith basis. You're not entering into it just for the purpose of immigration benefits. You want to make sure the person, and I also mentioned some red flags after answering this question. You want to make sure that the person filed their taxes at least for the last 5 years. You want to make sure that the person does not have any criminal records. Let me make notes on criminal records because I will tell you a story on that. The person does not have any criminal records. At least the person has a place to live because you know that you need a joint lease, right? So you have to prove that you cohabit with this person, and so a joint lease is going to help you do that. And the person has done some work, right? This will lead me to maybe one of the first red flags that I'll share with you. If your U.S. citizen spouse has not paid their taxes for a while, and their income, I mean, they haven't worked for a couple of years, and it's not as though they were sick or there was a triggering issue why they couldn't work, but it was just because they didn't want to work, right? And then you get married to them. USCIS officer reviewing this petition is likely to look at it differently. You don't want to put yourself on the dating market and then marry a US citizen who has never filed taxes because they don't work. Now, it's very easy for the USCIS officer to assume that you are paying them, right? So be mindful. Number two, criminal record. I had a consultation with a prospective client, and the person had filed for marriage base, received a denial. So they sent me the denial notice, and this was the story. This person married a US citizen guy, and the USCIS invited them to attend an interview. The guy couldn't attend the interview, so the lady went by herself, and USCIS didn't conduct the interview because the principal applicant was not there. And there wasn't any exception that could apply where the officer was going to waive the fact that the principal applicant was not there, and so we'll just interview the beneficiary. That didn't happen. And so around the same time, there was evidence of the US citizen spouse's actual wife call 911 to come to their home because of a domestic violence issue happening there. And so when 911 showed up during the investigation, they asked the woman, "Who is this man?" And then she said, "That is my husband. We've been together for at least 6 years." And remember that on paper, the man was married to someone else, right? And so the guy couldn't attend the interview simply it wasn't because he was working or anything. It was simply because he had, got into this altercation with his actual wife, and it was so bad that 911 got involved. And so the transcripts are there, the evidence is there. So on paper, this Ghanaian lady who is married to this man, and remember, this man had prior convictions already, prior criminal records. And so it's very easy when you put yourself on the dating market and you fall in love with a US citizen who has a past criminal record. It's very easy for the USCIS to dig deeper to see. And so they conducted an extensive investigation, and then they even got to know that around the same time, a day before the interview was when 911 was called, police was called to the house, and then all these things came up. And so fast forward, USCIS denied the petition because it was very clear. The transcripts that they had from the 911 call show that I'm in the house with my husband and he's beating me, he has a gun. Meanwhile, this husband is also married to another wife who is supposed to be attending an interview with him the following day. And so one of the things you want to ask is whether they have any criminal records, right? And don't believe it when they say yes, don't believe it when they say no. Tell them to prove it, right? If they say no, just tell them, get me a police clearance. I want to see it. Also make sure that the age gap, I think on Wednesday I said this in my webinar, age gap is also a problem. If you're, and I'm not going to cite any particular age, but taking the age gap in isolation may not be a problem, but putting it together cumulatively with all the pieces of evidence, that can be a problem as well. And so these are some of the questions that you have to ask when you're putting yourself on the dating market and decide to file for the marriage-based. I'll take a few more questions and I will be out. Okay. Someone says I have filed the I-130. It's been 3 months. Oh, come on. 3 months is not a long time. 3 months is not a long time. So if you have filed for the I-130 and it's taken 3 months, 3 months is not a long time at all. Um, Tell your attorney, that is if you had an attorney, tell your attorney to contact the USCIS. But 3 months is, I won't worry about it. 3 months is not a long time. Okay. 3 months is not a long time at all. So, okay. Can you get an adjustment of status after your I-130 has been approved? It depends. If the principal applicant, the one that filed the I-130 for you, is a US citizen, you should be able to file your adjustment of status, right? If they are green card holders, and I think I answered this question already, you want to wait for the priority date to become current. It's at that point that you can file for your adjustment of status. All right. So the USCIS issued an update that it is now accepting I-485 online filing for sudden employment-based applicants. If you know anything about the I-485, it is what gives you the green card. It's what gives the foreign immigrants the green card. Now, anytime you file the I-485, you're also supposed to file or submit the medicals. USCI says that, yes, you can submit that electronically, but you have to keep a copy. Don't keep just the copy of the medicals, but also keep the envelope in which the medicals came in, because during your interview, they would love to see that. They would like to see that. And so they are now beginning to accept I-485 for certain employment-based applications. But when you do submit that, please make sure that you keep the envelope and the physical copy of the medicals. I want to talk to you about signatures. I want to talk to you about signatures, the signatures that we submit when we file for our immigration benefits. So USCIS does not accept electronic signatures, right? They want the wet ink. So you have a pen, you sign, that is what they accept. They don't accept electronic signature. But of course, if your attorney is out of state, then you're going to sign and then scan, email it to your attorney, and or even mail it, right? If you're mailing it, I mean, what we submit is we ask our clients to use the wet ink, scan it, and then send it to us. But then when they are attending the interview, USCIS would love to see the original copy. I received a denial notice for a prospective client. Someone consulted with me, and the issue was about signature. The USCIS says that they doubted that that was the actual signature. And I remember it triggered my memory to an RFE that I received last year for the EB1. I filed the EB1 for a client that was in Ghana at the time. I mean, he's here now. That was in Ghana at the time when we submitted the petition. And the USCIS issued a request for evidence. Now, the issue with the signature, there were two issues that came up with the signature. The first issue was that the USCIS stated in the request for evidence that the internal document, so this person, top tier person in the organization, this person's signature on internal documents was different from the signature that we submitted. But this person at the time when we were submitting the petition had come to the United States for an event. And so they came to our office to sign. So we didn't even submit to the USCIS a scanned copy. It was the actual copy. USCIS came back and said that because the two signatures were different, and for the first time, this person said to me that in Ghana, it's okay to have two signatures, one for business and then one for other transactions, which was quite. I mean, I have lawyers that are barred in Ghana in my office, and so it was very easy for me to inquire whether that was true, and I quickly realized that wasn't true. but USCIS questioned the signature. And so please be on the lookout. When you even do the wet ink signature, you sign with a pen and you scan it to your attorney who is out of state. During the interview, please carry with you or just keep copies of the actual paper, the one that you signed. You want to keep a copy so that when you meet your attorney during the interview, you can simply hand it just in case the USCIS request to see it, because we're seeing that a lot now as well. All right. Are there any other questions? Let's see. Um, okay. Someone is asking whether they can file the EB1. I just answered that question. Go ahead and file. Please file. Submit your petitions. Um, okay. Oh, Usman, I filed. Let's see. Okay, so you did it on Sunday. Oh, that's been a while. Okay, we'll take a look at it. We'll take a look at it. Sunday, it's been a while. I'll take a look at it and then respond. Okay, I'm not. Someone says hi, mommy. I'm not mommy. My name is Akosua. Call me Attorney Akosua. Okay, if you want to speak with me, please head to our website and then schedule a consultation with me. Yeah, I see my assistant is here. Can you please post the consultation link on TikTok so that just book a consultation with me and I'm happy. So you see, when you schedule a consultation, you're giving me the permission to understand your history, how you enter the United States, if you lied your way into it, where the petitions that you have filed in the past, the results that you got or decisions that you received, what pathway you're looking to explore, and then you give me the permission to understand your history. So did what you submit earlier, because I have had NVC contact me, and this was for a client in Nigeria. The initial birth certificate we submitted was not, I won't say, but probably outdated. And so sometimes they just need a new one, right? And it's not out of place if they request for that. Just send it to them. It's not out of place that they request for that. So if the NVC request for that, just send it to them. Okay. To reopen from I-485 or refile, which one is better? It depends. It depends.
I didn't get that. Could you try again?
Okay, I'm not sure what is happening here. It depends. It depends. What was the basis of the denial? So, depending on the basis of the denial, then you will be able to make that determination whether to reopen or refile, right? Depending on the basis of the denial. But if your I-485 was denied, it's rare. I'll tell you this, it's rare for a USCIS officer, and I'm saying it's rare because I haven't seen it often. It's rare for a USCIS officer to misapply the law when it comes to the from I-485 for marriage-based or even employment-based. Most of the time, what I have seen when people have consulted with me on the basis of a denial of their Form I-485, it has always been because they made a mistake. They completed the form on an outdated form. You know, USCIS is always updating the forms with new edition dates. So sometimes that is what happens. Sometimes their medicals have expired. There are lots of reasons why Form I-485 will be denied, but it's rare to see a USCIS officer misapply the law as far as an I-485 is concerned. And so if your I-485, which is what gives you the green card, has been denied, but you believe that the denial was on the basis of a misapplication of the law, then just file a motion to reopen. Okay. If if it was your mistake, your preparer's mistake, or your attorney's mistake, please go ahead and resubmit. That will be my advice to you. Just go ahead and resubmit. I understand that is going to be, quite expensive. The I-485 is 1,440. That's a lot of money, but sometimes that is the only option that you have. And so it depends. It depends. Okay, it depends. I would easily refile. I haven't experienced that yet. So, but it's rare. It's rare for an I-485 to be denied because there was a misapplication of the law. Most of the time, the denials I've seen when people have consulted with me, they know that, oh, I made a mistake here. And then the issue is now I don't have the money. And so filing the I-290B, which is a motion to reopen or reconsider, I believe it's only $800 compared to refiling, which is 1,440. And so most people will gravitate towards the reopen or reconsider than a refile. But it all depends on the basis of the denial. Okay, that's a very good question. That's a very good question. Okay, let's see. Okay, so for some of the banks, please check Capital One, check PNC, Navy Federal. I know they'll request for your social security. I know Bank of America, and oh my God, Chase. Chase is also going to request for your social security. But check with Capital One. And I'm very confident with Capital One because I've had clients that didn't have social security be able to open accounts with Capital One, because there are lots of immigrants that have accounts with Capital One, lots of them, especially the Spanish folks, lots of them. And so please check Capital One. Okay, check Capital One. I believe Capital One will be able to help you. Okay, all right. So it's almost 7 p.m. Let's see. I think I've covered everything that I wanted to cover. The biggest piece that I want to leave with you is immigration fraud. Please be on the lookout. Like I said, it's not just about fake marriages. It's also about not disclosing prior marriages. I made a video recently. Most of the time you don't get married in courts, right? You get this traditional marriages done, and you don't have anything to prove that you're married, and so you choose not to disclose that. Please disclose that, right? So some of the common mistakes, that's a misrepresentation, not disclosing prior marriages, not listing your children, and also providing false work history. I've seen people get their petitions denied because of that. Okay. So some of these small omissions can lead to lifetime ban, removal proceedings, where you receive the notice to appear and then denial. Please be mindful, be mindful, be mindful. And when you're getting your witness statements, when you file your marriage based petitions and you're getting people to put statements together, please make sure that when the USCIS decides to investigate you, these people will be able to attest to the fact that they wrote the letters. All right. It's very important. It's very important. Someone just asked the question whether receiving requests for evidence is something to be worried about. No, it's actually one of the reasons why I love immigration. Right. So when you receive a request for evidence, the USCIS is saying that we have reviewed your petition, and before we make any decision, we are giving you the opportunity to give us more evidence. Give us enough evidence to be able to make a decision on your petition. That's basically what a request for evidence is asking for, right? Request for additional evidence is asking for. Should you be worried unless you lied and don't have that evidence? That's when you should be worried. But if you have the evidence they're asking for, I mean, whether it's employment based or marriage based, if it's employment based, most of the time a request for evidence is asking you to, again, we discussed the proposed endeavor. A request for evidence is asking you to tighten some loose ends when it comes to your proposed endeavor. And what I have seen a lot recently is that your proposed endeavor is tied to substantial merit and national importance. And so once your proposed endeavor is weak, then the USCIS officer reviewing it does not see the importance of your endeavor to the nation. And so they simply give you the opportunity to explain or provide enough context so that they are able to make a decision. And so don't be worried when you receive a request for evidence. Take your time, read through it. I just shared a moment of vulnerability with you when I received a request for evidence for an R1 petition that I filed for a school, a Catholic school that was petitioning for someone, and I received a request for evidence. When I read it, I was shaken, to be very honest with you, because I gave them everything they needed. And when I draft petitions, I always look at the policy manual, which is the law. I look at the policy manual, and so I have a checklist of what the policy manual requires, and so I make sure that I check all of them. And the USCI still came back with a request for evidence that shook me a lot. But I shelved it, like I said, went back to it after 2 days, proposed a strategy to my clients. We discussed the strategy, and then I said, just get me these evidence. They gave me the evidence, and once we submitted the response to the request for evidence, I believe in 2 weeks we received an approval. So request for evidence is not entirely bad. Sometimes the officers really don't know what they're doing. Sometimes they come back. I remember last year I filed an O1 petition for a client in Nigeria, and it was as though the officer that read the petition, that processed the petition, didn't read the petition. It's as though they just went into the system and printed something and sent it to me as an RFE, because everything they were requesting for, they already had it. And so sometimes it can be very annoying, but I politely responded, thank you for taking time to review this petition. However, everything that you are asking for, I have already submitted it. So request number one, you're requesting for this response. Then I refer them to previously submitted evidence, Exhibit 2A. The evidence is there. Request number two, I ended up referring them back to what I had already submitted, and we received an approval as well. So sometimes, just sometimes, you get caught up in the system. It doesn't mean that your petition was not good. It's just because that's just where we are. Okay. Okay, so someone says it's been over 2 weeks since you sent the request for evidence to your lawyer, and your lawyer is yet to respond. So remember that when you receive a request for evidence, I believe you're given 90 days. Unless you receive a NOID, a notice of intent to deny, a notice of intent to revoke. If that is it, then you have about 30 days. But if if it's a regular request for evidence, then your attorney has 90 days, I believe, to respond. So I understand that you have sent your request for evidence to your attorney. If she has not responded yet, just give her a simple nudge, nudge to remind her. And then maybe they're overwhelmed, maybe they haven't seen the email, which happens a lot, or they'll get back to it, right? Especially knowing that they have time. And so I don't think your attorney is being rude or disrespectful. I understand that it can be very frustrating. Trust me, I do. I do understand that it can be very frustrating. And I can't even judge your attorney because I miss emails too from time to time. So extend some grace to your attorney, but just give her a nudge to remind her about the RFE and let her know that you are a bit concerned because you haven't heard from her. I'm sure she's going to respond to it. Okay. Perfect Migration Agency. Can you please go ahead and resend whatever you sent to me? Or just send an email to info@ablegalconsults.com. info@ablegalconsults.com. All right. So also submitting fake employment letters, altered bank statements. I'm still on immigration fraud. That's the last piece I'm giving you before I get off. So bank statements. Listen, it's not enough to submit a bank statement like it is the active transaction in there. And please don't alter your bank statements. Don't alter any document that is not in your custody, right? That a third party. Well, first and foremost, don't alter any document. But it's even worse when you alter a document that is also within the control of a third party. Because USCIS can easily contact the bank and say that we want you to provide us with this document. They can easily request for it. Easily request for it. And I have seen this before. I had a prospective client reach out to me, and in fact, for her case, there were two outstanding issues. One, she had access to the driver license of some of her friends. And so when she was putting her petition together, and typical immigrants, we don't disclose when we are filing immigration benefits, just like we don't disclose when we are traveling when we are traveling abroad. I almost said the United States, but the United States is not the only country people travel to. So typical immigrants, we don't disclose when we are traveling, right? And it's the same. This person didn't disclose to any of her friends that she was filing an immigration petition. And so she had access, they are very good friends. So she had access to their driver license and then two of them, their passports. And when she was filing her immigration benefits, knowing that they were very good friends, she didn't even seek their consent. She wrote letters on their behalf, signed the letters on their behalf, and then attached their passports and driver license to the letters, added them to her packets, and submitted it to the USCIS. When the USCIS was investigating her, they contacted them. And you know what the USCIS did? They didn't mention her name. They mentioned the principal applicant's name, who is the US citizen spouse. They mentioned the US citizen spouse's name, and the friend said, we have never heard this name. And so please make sure that you're not submitting fake letters as well. Make sure that whatever it is you submit to the USCIS are genuine, legitimate documents, genuine documents, so you don't set yourself up. All right. And in all you do, please be mindful of your social media as well. All right. Okay. So if you're looking for an attorney to help you with your immigration petitions, please give my office a call, 703-705-9905. If you would like to join our WhatsApp group page, please send a message to WhatsApp number 703-705-9905. The number again is 703-705-9905. And please follow our social media platforms. On summer, we are going to have an immigration clinic. Immigration clinic is going to be free. Free. You come in, you speak with me within a limited time, 15, 20 minutes. And if you decide to retain us within the same day, you're going to get a discount. So we're going to have an immigration clinic here in our office in Springfield, Virginia this summer. Please follow our social media pages. So if you're in the DMV area, please be on the lookout. Even if you are outside of the DMV area, if you call us the same day of the immigration clinic, you get to speak with me. You can also schedule ahead of time. We'll put the dates out there. You can schedule ahead of time to speak with me. And if you do retain, and it's just going to be on some of our limited services, it's not going to include any employment based. It's just going to be the marriage based naturalization as well. It doesn't include removal proceedings. It's just going to be marriage based green card petitions and then naturalization. So we are going to have our immigration clinic, which is going to be free. You come in, you speak with me, or you call, you speak to any of our attorneys here. We listen to your case. We propose a strategy. And if you decide to retain us on the same day, you get a discount. Okay. So please keep an eye on our social media pages, and you don't have to be physically present here. If you call us, we're going to have people on standby. We have 4 phones in this office. So we're going to be quite busy on that day. So please follow us across all social media platforms, AB Legal Consult, across all social media platforms, Facebook, TikTok, YouTube, Instagram, and then LinkedIn as well. Please follow us, all social media platforms. The dates will be announced. And oh, there's one last thing that I need to talk to you about. It's about the immigrant's guide. I put together an immigrant's guide. It's right here. Please give me a second. Let me grab it real quick. Okay. So I put together the immigrant's guide. It's a booklet that before I put this book together, I spent time to read every immigrant's guide on the market. And I wanted this to be very different. I wanted it to be practical. I've had a few people purchase it and then given me a review. And on Wednesday in our webinar, I remember someone said, I purchased this book and it's very, very, very insightful. So this has real life experience. It's not for only those in the United States, only those coming to the United States. So it's for everybody, right? Whether you're looking to relocate from abroad to the US or you are here trying to navigate the system, the Immigrant's Guide is for you. It's on Amazon. The electronic copy is just about $5. If you want a physical copy, it's less than $15, less than $20 actually to purchase. Please head to Amazon and make a purchase. It's for everyone, right? It gives you strategy if you're looking to relocate to the United States. And if you're already here, trying to navigate the system, whether through marriage based, employment based, or even deportation, right? This book is going to help you. Number 2, it doesn't just talk about pathways, it also tells you how to navigate the system, the things to do, the communities to look out for. There's something called a credit score, right? How do you even get credit? These are things that I wish I knew when I entered the United States. There's so many things that I wish I knew, but I have put everything in here. It's on Amazon. Please head to Amazon, grab a copy, and then read it. I promise you, you are not going to regret it. I think my favorite part is reflection for readers. You know, that is chapter 7. When you enter the United States, there's so many things that comes to mind. What are the things you consider when you become a citizen, right? How has your immigration story shaped who you are today? In what ways do you hope to participate in your new community? And of course, it also has my number. So when you get stuck, but you won't get the number until you purchase the book, right? When you get stuck, help is here. So give me a call. It's in here. Navigating your first steps is in here as well. And everybody's favorite, marriage based, is also here as well. Understanding marriage based, which is chapter 4. I believe when you purchase this book, you probably won't get a lawyer. There's also employment based in here. I've highlighted some people in the case I disclose their names. It was only one person who gave me consent to use his name, Shank Comics. Shank Comics is my client. We did the O1 visa for him, the Nigerian content creator. So he gave me permission to put his name. So I put his story in here, what we did for him to get his O1 visa. And please head to Amazon, get a copy of the Immigrant's Guide. It's affordable. Of course, it was written by an immigrant for immigrants. So it's quite cheap. All right, guys. So I'll see you next week. Please keep an eye on our social media pages for what's coming. I promise you, you're going to enjoy the immigration clinic, and we have lots of activities coming up as well. Enjoy your weekend. My name is Akosua. Kisi, if you're looking for an attorney to help you with the immigration benefits, petitions, please give my office a call, 703-705-9905. You don't have to be in the DMV area to retain me. We have systems and structures in place for clients across all 50 states. All right, so you don't have to be here to retain me. Feel free, DM us, call us, WhatsApp us, and we look forward to seeing you next week, Friday. Oh, also on Wednesdays, we have a webinar. I always have a webinar with a group of people. The meetings are not recorded. I take questions from people where they unmute themselves, speak with me, and it's at 5:30 every Wednesday. So if you want to be part of that webinar as well, please follow our social media pages. I believe they'll send you a link to join. And also WhatsApp the 703-705-9905 number. Let me know you want to be part of the WhatsApp group. We'll add you. We post the Zoom link there on Wednesday, so you can be part of the webinar on Wednesdays. I look forward to seeing you next week, Friday. Thank you so much for joining. Enjoy your weekend. Good night. Okay, let's end this.